So you've been arrested. Maybe you saw it coming. Maybe you absolutely did not. Regardless of whether or not you saw it coming, criminal cases go through a certain process. Now, there is a difference between felonies and misdemeanors. So today, I'm going to talk a little bit about some of the stages that felony cases go through. All right. First, you have the arrest. When the arrest is made, you'll hear things like you have the right to remain silent. You have the right to an attorney. If you can't afford one, one would be appointed for you. It's important to remember that they're not just saying that because they enjoy it. They're saying it because those are your rights. You have the right to remain silent, and you should do so. Anything you say may be used against you in the court of law. Will be used against you in the court of law. I've had clients who talked themselves into additional charges because they thought they could talk themselves out of the back of the police car. No. You have the right to remain silent. Just do that. Once you're arrested, you'll be booked in to the jail, and they have their own process there. Once you're booked in, at some point within a day or two, a judge will set what is called a bond for you. The bond is there to make sure that you will come back to court for any court date that comes up if you're released. So what level of guarantee do they have that you're going to continue to show back up for an event at which you may end up right back in jail or prison, right? And they set that dollar amount, and then it's on you or a family member or a bondsman to come and get you out of that situation. Very quickly thereafter, you'll have what's called the arraignment. The arraignment is where they're supposed to tell you what you're charged with and make sure that you're actually the person that's identified as having committed the crime. Typically, what it is where your attorney will show up and say that you're there and enter their appearance, waive the reading of the charges, and they will set your next court date. It is a fairly formalistic check-in type of court date. Not much is accomplished other than confirming that you're there and whether or not you have an attorney, sometimes making sure you understand what you have been charged with. In the state of Oklahoma, charges are made by what's called an information. That's just a piece of paper that lists out the charges and has the signature of the district attorney or assistant district attorney who filed those charges. After you've been arraigned, the court will set a preliminary hearing date. In felony cases in the state of Oklahoma, you have the right to a preliminary hearing. A preliminary hearing is the first or preliminary hearing in which the evidence is going to be examined. And it's not much of an examination. The question is there probable cause to believe that a crime was committed and that you committed the crime? Most of the time, if you're getting to a preliminary hearing, the state feels like they've got probable cause that you committed a crime. There's not much of an opportunity to put on defense evidence at a preliminary hearing beyond cross-examination. But the state puts on its witnesses that it has. Your attorney has the opportunity to question those witnesses and poke any holes, and then the court will take up the issue of whether or not probable cause has been established. Once that hearing is done, your case will then be bound over for district court arraignment. That is where you'll appear in front of the judge who will actually conduct the trial of your case. This is where your case can really become dispositive. Are you going to go to a jury and have the jury decide your guilt or innocence? Are you going to enter a plea? Are you going to do a non-jury trial and have the judge deciding your guilt or innocence? These are dispositional events. And between district court arraignment, your first appearance in front of that district judge, and sentencing or plea, motions can be filed, waiver of jury trial can occur. Once you get to jury trial, you'll have a jury selection process, and that is where your attorney and the state's attorney will attempt to find the jury that's most likely to find you guilty or not guilty, depending on which of those attorneys is speaking. It is the hunt for an impartial jury, and then you commence with your jury trial in which the state will put on its evidence. At the conclusion of the state's evidence, you'll have the opportunity through your attorney to put on your case, your defense, your evidence, your witnesses. And after that's done, if you have been found guilty, there will be a sentencing. All of this can be fairly complex. None of it should be done without an attorney. Frequently, people will ask, oh, can I represent myself? I mean, physically, you're capable of it, right? You can walk yourself into the courtroom and open your mouth and utter words, but you won't know what you're doing. At Parsons, Graham, and Day, we focus on criminal defense every single day. We're in front of judges that handle criminal matters every single day. So if you find yourself facing a criminal charge and you need an attorney that has the experience and the understanding to get you through it, call us at 918-307-1529.